Now, you may enjoy the bloodlust of seeing a young woman shot to death by law enforcement. There are a lot of Americans who want to see a white woman married to another woman shot to death by an ICE agent. I know this country. Trust me, plenty of Trump supporters are not so secretly glad she was killed. Okay, I can't change people's pathology. I can't change how people feel. But the law and the truth are immutable. Whoever fired that weapon at her committed a crime and belongs in prison. Again, that's not a matter of opinion. That is the law. In 1985, the Supreme Court ruled in Tennessee versus Garner that police officers are forbidden from using deadly force to apprehend a suspect who is fleeing. Now, up until that ruling, Tennessee police were allowed to use their weapons to stop someone running from the scene of a crime, violent or nonviolent, property crime. According to Tennessee law, police could use their weapon to stop someone fleeing from any kind of crime. According to the statute, in effect, until the Supreme Court overturned it in 1985, this was the law before the Supreme Court overturned it, if after a police officer announces their intention to make an arrest and the suspect then tries to escape, the officer would be in their right to use whatever force is necessary, including a deadly bullet, to prevent that escape. That law was based on British common law going back centuries, when law enforcement, such as they were back then, law enforcement only had access to primitive weapons. They write about this. Byron White wrote the majority opinion, and he said, we're talking about different types of weapons now. He said, back then, when this law was written, law enforcement had primitive weapons that were more likely to miss their intended target or leave a flesh wound rather than kill somebody. In his majority decision, Justice Byron White wrote that the precision and deadliness of modern weapons necessitates law enforcement officers to refrain from firing their weapons because the death of a fleeing suspect is far more grievous than whatever crime that suspect is wanted for, unless it's a violent crime. The court ruled, this is the law. Now, you may not like this law, and you may think that this woman deserved to be shot, but the court ruled that if a suspect is fleeing a nonviolent crime where the arresting officer doesn't believe the suspect is a physical threat to the community, that officer is forbidden from firing their weapon. In other words, if a fleeing suspect is about to be arrested for a property crime as opposed to a violent crime, shots cannot be fired. Justice Byron White, in his majority opinion, wrote in 1985, quote, "It's not better that all felony suspects die than that they escape." In Tennessee versus Garner, the Supreme Court established what is called the Garner Standard. Law enforcement officers, including that ICE agent who shot Ms. Good, law enforcement officers must consider two questions before firing their weapon at a suspect who is fleeing from the scene of a crime. One, is the suspect aiming or holding a weapon that poses a threat to the officer or anyone in the immediate area? Two, is the suspect believed to have just committed a violent crime? Otherwise, officers are forbidden from discharging their weapons. This 1985 ruling stems from a 1974 incident where a Tennessee police officer responded to a call reporting a home burglary. Police officer Elton Hyman and his partner arrived on the scene. They spotted 15-year-old Edward Garner running out of the house towards a 6-foot chain link fence that 15-year-old Garner was planning to climb over and escape with what later turned out to be a purse containing $10. So apparently he stole $10, a purse with $10 in it, from that house. He was 15 years old. Officer Hyman ordered 15-year-old Edward Garner, who was all of 5'4" and about 100 pounds, he ordered him to stop or I'll shoot. Garner, 15-year-old Garner, continued to climb the fence, and Officer Hyman, using his .38 caliber revolver, fired one hollow-tip bullet to the back of Garner's head. Garner was taken to the hospital where he was pronounced dead. Garner's father sued the city of Memphis, its police department, as well as Elton Hyman, the officer who fired the deadly shot. Lawyers for Hyman, the officer who fired the deadly shot, lawyers for the city of Memphis, lawyers for the Memphis Police Department, argued in the lower courts that Hyman, the officer, was well within his rights to fire at 15-year-old Garner thanks to this Tennessee statute that permits an arresting officer to use deadly force if, after announcing his intention to make an arrest, the suspect attempts to flee. That was the statute. So he wasn't, the cop wasn't breaking any law. That lawsuit kicked around the lower courts for 11 years. It finally made its way to the Supreme Court, with the core issue being the constitutionality of Tennessee's use of deadly force statute, stating an officer may use, quote, all the necessary means an officer may use, quote, all the necessary means to effect an arrest, unquote. All the necessary means to effect an arrest, even if that means killing the suspect. Now, that Tennessee statute was on the books in about, I don't know the exact number, but let's say about 22 other states. Again, lawyers for this officer argued Tennessee law permitted him to fire at a fleeing suspect, even though the 15-year-old Garner was unarmed and was not suspected of committing any violent crime and posed no physical threat to the officer or the community. So, if this kid had gotten away, was there the possibility he might have committed more home robberies? Maybe. But was there ever the possibility that he was going to commit violent crimes? And that answer is no. In our law, there is a distinction that is made between property crime and violent crime. Rich people rarely get convicted for property crime. The prosecutors always agree it's a misunderstanding, or why ruin someone's life over some minor indiscretion. That's if you're rich. But if the suspect is a person of color or poor and is found guilty of a property, the prosecutors will prosecute property crime if you're a person of color or you're not rich. And it will carry a prison sentence in order to keep our multi-billion-dollar prison, for-profit prison industrial complex humming. The Supreme Court in 1985, I'm having trouble talking. This took a long time to prepare, and I've had no sleep. The Supreme Court in 1985 ruled that police officers cannot kill someone fleeing the scene of a non-violent crime. The court also ruled that shooting an unarmed suspect fleeing the scene of a non-violent crime violates that suspect's Fourth Amendment rights. Fourth Amendment forbids the police from conducting illegal search and seizures. Okay, so the officer, it's a little complicated, but it makes sense if you think about it. In terms of the Fourth Amendment, the officer who fired the shot that killed 15-year-old Garner, he's not a judge, he's not a juror. He only suspected the 15-year-old of committing a home burglary because he was fleeing the scene of a home burglary. But it was all circumstantial evidence that must be what? Adjudicated in a court of law to determine whether 15-year-old Garner was in fact guilty. An officer, as you all know, cannot serve as judge, jury, and executioner. That's where the Fourth Amendment comes in. This 15-year-old Garner's Fourth Amendment rights were violated, along with other civil rights, because that deadly shot to the back of his head prevented him from being able to defend himself in a court of law and present evidence to defend himself. So it was a form of illegal search and seizure. By killing him, the officer destroyed the evidence. A police officer is not allowed to shoot someone just because that officer or ICE agent has reasonable suspicion that the person he's aiming his gun at is guilty. Officers can only make an arrest based on reasonable suspicion. They cannot empty their gun on reasonable suspicion unless the suspect is believed to have committed a violent crime and is pointing a weapon at either the police officer or the community. And again, that officer can only fire his weapon, her weapon, their weapon, if that officer believes the suspect is either armed or dangerous. Now, armed is okay. In other words, you can't just fire at somebody because they're armed. In the United States, it's okay to be armed. These days, practically everyone is. But was the suspect armed and dangerous? Was the suspect brandishing the weapon? If the suspect had a gun and the suspect is... Anyway, I don't want to... Okay, so in her dissenting opinion, Justice Sandra Day O'Connor joined soon-to-be Chief Justice William Rehnquist and then current Chief Justice Warren Burger. She wrote a dissenting opinion warning that the Garner decision, this was in 1985, the Garner decision created a constitutional right for unarmed suspects to flee from the scene of a nonviolent crime. So what do you think? Leave a comment. Do you want to live in a country where nonviolent criminals can try to flee the scene of a crime without officers shooting them? God forbid the police officer chase them. God forbid we have police officers who can still run. Do you want to live in a country where police officers can stop any suspect by shooting them in the back? Okay, that is the law. Tennessee v. Garner.